I'm happy and proud to present our General Counsel, your friend and mine, Jeff Young.
All right, so how many of you are excited to talk about rules? Well, so most of you are well seasoned, I think, probably in the rules. So this will be just sort of a, and David's laughing. Will probably be just sort of an overview and scratching the surface for many of you, but it's at least a good reminder. So what I want to do today is I've got a few goals here in mind. I want to explain the relationship between the Personnel Act and the board rules, right? The laws and the regulations. Name at least 3 areas covered in the board rules. We're going to go over more areas, but at the end of the day, we're going to have like a little quiz maybe and see how many you can name, right? And then name at least 3 actions that require the state personnel director's approval. So hopefully we can do that too. And then of course, be able to find the board rules, right? All right, so let's start with the Personnel Act. Can anyone tell me when the Personnel Act was enacted? A guess. 61, 62. You know, I think there was actually an earlier version in 1953, but it was enacted as an act in 1961. So that's sort of what we're dealing with in terms of the time frame here. And I'm not sure that a whole lot's changed in the statute since that time. There have been a little bit minor tweaks here and there, but it's still a pretty old statute. So when we talk about a statute, when I'm referring to the Personnel Act, it's obviously passed by the legislature. The legislatures say this is an important thing for state government, and really what they were looking for is trying to find a system of administration that would meet the needs of the state personnel and be a fair and equitable process across the board. And so when they were enacted, they fell into the NMSA 1978. Well, they are now in that section, and that's how you cite the section. I don't have the actual section number up there, but that's how you would cite the section if you're referring to the Personnel Act. And then, of course, that's the full New Mexico statutes annotated. So what are the rules then? The rules are actually what the statute has been authorized. The statute authorizes the agency to make rules, and in this case, it's the State Personnel Board rule, right? So they are in the New Mexico Administrative Code, and this is the citation format there. There'll be a number for the rule site, and of course, it's in the New Mexico Administrative Code. All right. So this is the purpose of the New Mexico, the State Personnel Act. So establish for New Mexico a system of personnel administration based solely on qualification and ability. Qualification and ability. It's really a merit-based system. It's not seniority, it's not how many years necessarily you've been with the state, but it's really based on qualification and ability. So I think that's the key focus there. All right, a few highlights. The State Personnel Act covers all state positions in the classified service with noted exceptions, right? There are exceptions to the State Personnel Act. Some being that, elected officials, obviously, like the Attorney General's office, which is kind of an interesting example because there's actually cases on that where the AG's office had said, no, our employees and our whole office are not covered by the State Personnel Act. So we have our own process for dealing with them. Well, I think it was a Court of Appeals decision came out recently that said, no, that's not true, that maybe the Attorney General, right, is exempted from the Act, but the employees may not necessarily be exempted from the Act. It just depends on the nature of their job. So that's still, I think, going to be appealed to the Supreme Court, and we'll see how that shakes out. But there are exceptions such as those. GovX being another exception to the State Personnel Act. So every one of your agencies obviously have GovX folks in there that will be exempted. They follow their own rules. There's a handbook. I think it's on the DFA website that has the GovX rules. All right. So also the Act created the State Personnel Board. It has 5 members. We only currently have 3, right? And they're serving for 5-year staggered terms. So ideally, they'd come up for a term every year, but in staggered terms. The State Personnel Board is administratively attached to the General Services Department. So we're not our own department, we're an agency, and we're attached to GSD. All right, so other items covered by the Act, rulemaking, obviously. So those rules that we're talking about, the Act gives us authority to make rules. And the Act talks about certain types of rules like pay, classification, disciplinary process, all those types of things. Also, interestingly enough, veterans preference was in the Act. It's important to the legislature, and so it's a part of the Act. And the rules talk more about that. We'll also talk more about it. Certification of payroll by the Director of State Personnel. And then, of course, disciplinary appeals. It provides 30 days to appeal suspension, demotion, or termination, which is important. And of course, reduction in force. When that happens, not every one of your agencies will deal with a reduction in force, but some of the larger ones certainly do have this come up quite a bit. And then prohibited and lawful acts, which is usually a lot of political restrictions there. All right, so here are the duties under the Act for the State Personnel Board. They make personnel regulations, they hear appeals, review budget requests prepared by the Director, make investigation studies and audits necessary for administration of the Act, make an annual report to the Governor, establish liaison with GSD, and represent the public interest in the improvement of personnel administration. That's to me, a very important role that the board has, and one that could get the board dragged into lawsuits, by the way, but anyway. So public interest. Also supervise all administrative and technical personnel activities, act as secretary to the board, these are the director of duty, sorry. Establish, maintain, and publish annually a roster of all employees of the state, which we do. Make annual reports to the board, recommend the board rules, supervise all tests, which I don't know if there's a whole lot of tests going on, but that's one of the duties. And so that's sort of it in a nutshell. The State Personnel Board rules, there's actually 13 parts of those. So if you look at the organization, you see the NMAC sites, 1.7.1, et cetera. If you look at the rules, they're sort of organized in a fashion of almost covering employees cradle to grave, like when they're hired, what position they're hired into, their classification, their pay, how they're recruited, the working conditions, all these things are sort of in that life cycle. And hopefully you don't end up in this phase right here, but it's something as HR professionals we all deal with, of course, right? And then of course adjudication, appealing, and so forth, your disciplinary action. Oh, let me go back to, also one thing I would say is, Andrea, she's here, are you here? Oh, in the very back of the room. So she likes to refer these as rule 1, rule 2, rule 3, rule 4. When she's talking, just to shortcut that NMAC citation. And just sort of as a plug, as the director mentioned, we will be doing several installments of these, and she's got, I think, at least 2 on recruitment. And so she'll get further in depth in these rules as we go through. So, all right. So the rules also cover classified appointments, and in the definitions, all of these appointments are defined. And certainly, as we know, probation is less than 1 year, right? And if you have a break in service of at least 1 day, it will require the employee to serve another probationary period. And usually we're construing that as one business day, right? And so if there's a break over the weekend, not necessarily included unless that's part of the normally scheduled that the employee works. The probationary employee can be expired with 24 hours notice, right? No appeal to the board. It's sort of tough luck for the probationary employee, right? No appeal to the board, though. No appeal to the board. And so, unfortunately, that leaves a probationary employee with not many options. Of course, when you're dismissing someone as a probationary employee, you need to include a reason, right? Why you're probationary expiring that person, and that is required by the rules. So So yeah, keep in mind that you need to have reasons. You need to essentially have evidence, right, why you're dismissing that person. If you don't, and for unemployment, right? So you do need to have some evidence for that. And I know a lot of your clients will probably want to just sort of term someone who's in probationary status very quickly. And I would just caution that we do need to have some evidence before dismissing that person. And showing that they were aware of the policies or the practices and they violated those policies.
Oh, yeah.
So the career employee, that's someone who has obviously served their probation, right? And they are now a career permanent employee under this rule. That means they have property rights, right? And that's not every state does that, but New Mexico gives their state employees a property right. And to take away a property right, you need really some due process. And due process is sort of it's some of the cases out there, they have interpreted pretty loosely, like just notice, opportunity for a hearing, those types of things. But there is an actual process in our rules for dismissing someone in career status, which we'll talk about. Term employees. How many of your agencies have term employees? So about half of you, probably because you receive federal funding, maybe some state funding. But that's essentially a term employee who's working on a special project or a state or federal program. And that is usually for maybe a year or something like that, where there's funding in place. We know the funding is going to be there for a certain period. And after that, well, it may not be, and the employee goes away. We'll talk about some of the restrictions on that, but essentially they can be expired with 24 hours notice and no appeal to the board as well. The last category, emergency employees. Are any of you familiar with an emergency appointment? Okay, got one. Don't see a lot of those, but if there's a special need where there's an emergency, then we can put a person in a job no more than 90-day period. And that can be expired with 24-hour notice and no appeal to the board. All right, so moving along in our journey, the first main area covered by the state personnel rules is pay. And that is something important to all of us, right? And it's kind of interesting how, I think from the state personnel office's perspective, how these can be combined to make up a person's salary. All right, so going back to TREX, right? The temporary recruitment differential. The director may authorize this type of differential up to 15%. 15% of an employee's base pay. Now, this particular rule also allows the director to approve more than 15% under special circumstances if approved by the director. So keep that in mind, 15%. TRETS, which is the temporary retention differential. If there's a special argument that the person's departure would disrupt the agency's ability to fulfill its mission, then we might do a retention differential. And that's, again, 15%, up to 15%, and then more than 15%, special circumstances, but director approval. All right, temporary salary increases. So those can be up to 10% during a fiscal year with director approval. And the rule is interesting in this way that it doesn't allow more than 10%, right? Doesn't give the director discretion. So we've typically interpreted that as only up to 15% in pay bands of the 10%. So, okay, very good. All right, and the next one is salary upon promotion. Those are up to 15%. Oh, sorry, salary upon, I'm getting this all screwed up. Director approval for less than 5% or greater than 15%. So anything in between the agency could do for a salary upon promotion. Promotion. Got that one. Demotion, all right? So again, all these numbers. So it can't result in more than 15% decrease from the previous salary unless a greater decrease is required to bring the salary to the maximum of the new pay band. So that's demotion. All right, salary upon transfer. So that one is increased up to 10% upon transfer, and the director may approve a salary greater than 10% due to special circumstances. Let's see, reduction may be reduced up to 15%, and the director may approve a salary reduction greater than 15% due to special circumstances. So those are all sort of, the number 15 sticks in there quite a bit. First line supervisor duties. This is usually between 0 and 20% above the employee's base pay for performing first line supervisory duties. And of course, when those duties are no longer performed, the agency reverts the employee to the hourly rate they were at when they're not being performed. All right. So what was being mentioned was that this is not maybe a common rule that's used anymore because the reclassifications that were done included the supervisor category that was not there before. But there may be, to Andrea's point, the situation where you didn't have that supervisor category that you need to actually use this rule, I guess. But it's still currently in the rules. Probably does need to be reviewed, but that's where we are currently. Okay, so on the recruitment section, the recruitment part of the rules, Rule 5, all vacant positions to be filled shall be open for recruitment unless authorized by the director. So that's interesting, right? So really all of our recruitment should be open and advertised, and usually that means through share. But if we're not doing that for whatever reason, what do we need then to do?
Recruitment waiver. Recruitment
waiver, right? And that's kind of interesting because recruitment waiver is not mentioned anywhere in the rules, but we say it all the time, recruitment waiver. But that's what's happening there is the director's approving an exception to an open recruiting situation. So if we've already identified a candidate who's perfect for the position, we'll send the paperwork in to SPO, and the director may or may not approve a recruitment waiver for that position. Positions in the classified service shall be assigned at the classification appropriate, and a director may approve an underfill or a double fill. Agencies may allow part-time employees to share the same position. We'll talk a little bit about. All right, perfect, thanks. So again, on recruitment, rule number 5. Again, the selection must be based on qualification and ability. That's kind of a running theme. The Criminal Offender Employment Act essentially means that you can't ask for a criminal history in the application, right? And you can ask later in the hiring process after an offer has been made, but not. There is a process into, what's the timing that you can ask on the criminal history, and I think that's what we were discussing is that you can't ask for it on the employment application, obviously, but later in the process to do the background checks and things like that. But you can't take into consideration arrest that didn't result in convictions, and also misdemeanor convictions not involving moral turpitude. So, like lying and things like that fits into moral turpitude. There are some agencies that are exempt from from the statute, and those are law enforcement agencies. So DPS, and then corrections actually likes to use this example as well, or use this exemption as well. So there's that. What other things? So, this is an interesting, on this last bullet point on recruitment, is it says agencies shall be sensitive to creating diversity in the workplace. I personally think we need to have better initiatives on diversity in the workplace. So I hope that that's something the State Personnel Office will be doing in the future, but this is what's in the rule currently. All right. Still on recruitment, you can do temporary promotions not to exceed 12 months. The person still must hold the qualifications and abilities necessary for the job, which is important. And then after that temporary promotion occurs, the person will then go back to their former position without right of appeal. The intra-agency transfers is also one we talk about quite a bit, where the secretary or agency head wants to transfer I'm an employee from one position to another position. Could be a variety of reasons, but there is a rule on that. And basically, you can do a transfer without an employee's consent to a position in the same classification, right, within the same geographic location, meaning not more than 35 miles from the community in which the employee is employed, unless the employee expresses a willingness to change those locations. All right. For the exempt to career employments, basically I would say there is that the employment in the exempt service does not count towards the probationary period. So you may have some that are moving from a GovX position to a career appointment, and there's a question about whether that time as a GovX applies in your probationary. It does not under the rule. The reduction in salary or classification, employees may request a classification reduction to a position for which the agency certifies the employee holds qualifications and abilities necessary for successful job performance. This just means a voluntary reduction of the employee in their classification, which they may do for whatever reason, I guess.
But just so you guys know, like, I always look to see if the employee signed that document. It's on the part, there's a line that says I acknowledge. Like, I 100% every single time, because I'm always curious. Like, of course, people make choices in their life, and it's totally appropriate. But I always look to see did that person sign. Now, of course, the person can sign, but it's really important to know that someone's going to take a reduction, either in class or reduction in pay, and that they have knowledge that that's going to happen.
And if they're not acknowledging, that could be really more of a demotion situation that we've talked about that would not be permissible without cause, just cause.
But you would have to have a vacant position for them to go to, right?
Correct, yes. You would have to have a position for them to go into, particularly, I mean, if they're a career employee, obviously, yes, they need to have that. Okay, good questions. So absence and leave. I don't want to spend a whole lot of time on this because I think we're familiar with sort of the leave policies and everything, and each agency has their own leave policies. But you've got annual leave that accrues. I think if you're under 3 years, it accrues for about 3 hours per pay period. You can, of course, donate annual leave and or sick leave. What's that?
Sick leave is much more specific.
Yes, there are rules on the donation piece. So if you're interested in learning more about that, definitely look at the rule and see what the specific requirements are for donation. Sick leave, like I said, there's accruals there. Leave without pay, that there are restrictions on leave without pay. I think it's 30 days for probationary, up to 30 days. And then for the career employees, I think it's up to 1 year unless you have agency approval. So just keep that in mind. Family and medical leave, as HR professionals, we're aware of what FMLA is and what the eligibility requirements are. To be eligible, you have to have at least 12 months as a state employee and worked at least 1,250 hours, 1,250 hours during the 12-month period preceding the start of the FML leave. And then once you are eligible, you get 12 weeks of unpaid FML leave. So we always talk about FMLA as a job protection statute. It's not a paid leave. So a lot of people get confused with that. And, again, love to see paid leave for certain conditions. A lot of public employers and private employers are doing paid leave for these types of circumstances to help employees get through, because 12 weeks of unpaid leave is a lot to be unpaid. So we'll see how that progresses. Let's see, I think we've got absence without leave. From the disciplinary side, you guys know about absence without leave. Obviously, if the person doesn't have approved leave and they're absent, they could get docked with AWOL, absence without leave. I think the next one, administrative leave. So there's several administrative leave rules. This one I'm referring to here is the one in which the agency head can put someone on admin leave for up to 5 days if it's in the best interest of the agency to do so. That's pretty broad language, right? see that happen quite a bit, where for whatever reason, the person's put on admin leave for up to 5 days in best interest of the agency. There's a disciplinary one we'll talk about in just a second, but this one is in the best interest of the agency. If it needs to exceed 5 days, you have to get director approval on that. Educational leave. How many of you guys do educational leave at your agencies? Which agencies are those? Sorry, going back.
General services.
General services, okay.
Para.
Para. Any other ones?
Cultural affairs.
Cultural affairs, okay.
State land office.
State land office, okay.
State treasurer's office.
Okay. Got a good sampling there. And so there was a previous memo on educational leave that it said that it has to be for specific duties that the employee is performing. But the actual rule, because we're talking about the rule, it says that they can pursue special training related to their employment. So it's maybe a little broader than what we've interpreted it in the past to be. So I guess the note there is, if you have people who you're clicking for educational leave and share, be careful which one, and if it is eligible for para, then you want to make sure you use workshop. Okay. All right. I learned something new. Interesting. Okay. So where were we? Educational leave. Okay. So military leave. So reserve units of the National Guard can get up to 15 work days of paid military leave per federal fiscal year. And the governor can also grant members of the National Guard paid military leave for active duty training, and that's usually up to 15 days per year as well. And so there's usually a memo that goes out from the state personnel office that says that the governor is granting that. Members of the state defense force can get paid military leave to attend official training. This is only for full-time employees, and they must not exceed 15 work days per federal fiscal year. And the last one is the Civil Air Patrol, and they can get military leave not to exceed 15 work days. There's one more in addition. I think the reserve component of the U.S. Armed Forces shall get unpaid leave for training or inactive duty training in the official training or inactive duty training in the U.S. Armed Forces. All right, let's see. I think there's one more. It's personal leave day as well that we all get each year that I'm sure you guys are aware of and use. All right, so drug and alcohol abuse. Okay, this is another area covered by the rules. We see a fair number of questions regarding this because of reasonable suspicion testing and other types of testing. But the first one that I want to make sure you're all aware of is that each of you should have a substance abuse coordinator. And does everyone have a substance abuse coordinator? Yes, no, yes. Does not. Okay, good. Sort of. Okay, right. Yes. And so it's important to make sure you've got one at your agency, because that person is responsible for receiving the test results and for notifying and explaining to employees of the test results and the rights of the employee in that situation. So certainly important. Designation of safety sensitive positions. I'm sure a lot of you have those positions, right? And as we were talking about at one of our legal conferences recently, it's important that you look at this again, your safety sensitive positions, to make sure you've got them appropriately designated, particularly with the medical marijuana statutes. They talk about safety sensitive positions and how that act applies to those positions. So it's important that you get those sort of up to speed from that perspective. In terms of drug and alcohol testing, for those safety sensitive positions, you can do testing after an offer of employment and prior to final selection. And then all employees can be tested for reasonable suspicion. So if you see someone, there's an example of someone's, what they think is smoking, marijuana in the car or something like that, right? And there's a cloud of smoke, and you're like, So, I would caution on that front, right? Because we don't want to reach too many conclusions about that. I always say, what else do we have, besides smoke, right? Because we could be smoking a cigarette, right? But if you go by the car and you also smell marijuana. That's one thing. If the person's impaired, that's another thing. But I think you need to think about that and make sure that we're not making too many conclusions, presumptions without evidence to support that. So the rule talks about, testing for direct manifestations when someone's being under the influence, like, breath, slurred speech, those types of things, or direct observation of use if they're drinking a beer, right, at work, or in their possession of something like, paraphernalia or something like that. So yeah, it's something that we want to make sure we take some care with. And there's actually, under the rules, a memo that has to be generated where the next level supervisor's approval is needed, and the substance abuse coordinator within 24 hours of a request for a drug test. So there's some paperwork attached to that as well that I hope you are all doing as a result of the rule. Any questions on that, on reasonable suspicion or anything like that? Okay, all right. Of course, you need to use a state licensed laboratory for testing, not just some guy that just says, I've got this testing from Amazon. I think we've had that question before. I got a test that I purchased online. Can I use it? No, we need to have a state licensed laboratory to do that. And under the rules, there are cutoff concentrations for marijuana. I think it's like 50 nanograms. Right, Cliff? 50 nanograms. I think we talked about that. Not that you would know, but in one of our trainings, you pointed out it was 50 nanograms. Alcohol threshold is 0.04 for a positive test result. And of course, if they've gone to one of these treatment programs and they're tested, within 30 to 120 days or something like that, any concentration can be seen as a positive test result. So that's kind of it's a very strict threshold there. Also, you may grant administrative leave up to 240 hours if there's a voluntary self-identification of someone going to one of these programs. So that's a pretty big chunk of time. And of course, safety-sensitive position folks who are going to one of these voluntary programs, they can be assigned to a non-safety sensitive position during this time period while they're getting treatment. All right. So performance appraisals. This is rule number 9. Evaluations have to be initiated within 90 calendar days of appointment, reassignment, promotion, demotion, reduction, transfer, and/or the employee's appraisal date. How many of you are doing it within 90 days? I don't know. A lot of, there's one. You try, right? Yeah. But it's certainly in the rule, so we should be doing it. And then the evaluation under the rule is set to happen at least on an annual basis and a semi-annual basis for career employees by the employee's anniversary date. That's what the rule says, anniversary date. I think a lot of people are going by other dates as well. There were some exceptions made, but the rule says anniversary date. All right. Okay. So we'll move into the discipline. We're almost wrapping up here. And certainly you guys are familiar with this particular rule, Rule 11. Got to have just cause, just cause. And some of the examples listed in the rule are inefficiency, incompetency, misconduct, negligence, insubordination, unsatisfactory performance without a reasonable opportunity to correct it, absence without leave, drug and alcohol issues that were mentioned in the previous rule, falsifying official records, conviction of a felony or a misdemeanor when the act applies the Criminal Offender Employment Act. And so you have to have just cause if you want to do what 3 actions? Suspend, demote, or dismiss, or terminate. So you got to have one of those categories in there. So it's important in your notice of contemplated action, which we'll talk about in just a second, to make sure you're identifying one of those areas for one of those 3 actions. All right, so here's our little process, right? Got the notice of contemplated action. And then we have a period of time that a person can respond in writing within 11 days of receiving the notice of contemplated action, or they can request an oral response within 11 days. So if they're requesting an oral response within that 11-day period, then you have to meet with that person within 11 days from that oral response request. I have no idea why it's 11 days. Could be 10 days, right? But yeah, usually you see around, I would say 10 days, and in most states that I've practiced, you know, that's a rough amount. It's a fair amount of time. But those are 11 calendar days, right? So that's also worth mentioning. And then you'll send out the notice of final action. And within the notice of final action, you need to specify the effective date, right? The effective date of the action. And I'm going to talk about that in just a second. But notice, you've got to put the effective date. You've also got to describe the conduct and explain the evidence. And there's at the NFA section, there's no new allegations against the employee. From this point, the notice of contemplated action to this point, there's no new allegations, because if you have new allegations, the employee's like, what? I didn't know about that. And now you're telling me at the end, and I didn't have an opportunity in my oral response meeting to mention that. And so that's a problem. That is a problem. So really what happens if you get to this point, you've got new allegations, you're probably going to start over with a new notice of contemplated action. So you don't want to be in that stage. You also want to make sure you're following the timelines, because if you miss those, you're starting over. It's not good. All right, and then of course the employee can appeal then after receiving the notice of final action within 30 days. And that's again part of that property right for the career employee, that we're making sure they've got their ability to have their day in court. And as Lisa can tell you, and some of the other attorneys can tell you, it is like a day in court, right? There are rules and there's evidence, and it's pretty formal. It's a formal proceeding. If you're a union employee, a bargaining unit employee, you've actually got an option at this stage. You can choose an arbitrator, or you can choose an ALJ, this administrative law judge here at the State Personnel Office. There are currently 2 ALJs at State Personnel Office, and so one of those will get assigned the case if you go that route. But if you go an arbitrator route, it's not a state employee, it's someone off a list. And that's the employee's choice. And unions will often pick the arbitrator route, usually because there's a more favorable decision, perhaps, with someone who's an arbitrator. But it's costly to the employee, it's costly. I don't know what the costs are currently. I'd say around $2,500 per side. Is that about right? Maybe more, maybe more. 5,000. So it could be, somewhere in that range. It's expensive, and the ALJ is a free route. So that's why a lot of people pick that route. All right. So key director approvals. So we're just kind of recapping here on the director approvals. Actually, before I get to that, I'll talk about one more thing. Medical separations. Are most of you familiar with medical separations? So I would say that most of the time that's a preferred route if you've got someone who's unable to meet the essential functions of their job with or without accommodation, and they're just like, hey, you can't do the job because of the medical condition, and we're going to dismiss you, without prejudice, right? So the employee can apply again. But I would definitely look at that rule for medical separations if you have someone who has a disability. And there's different rules since you've got workers' comp illness versus a non-workers' comp illness. Under the workers' comp illness, you actually have to afford them modified duty, which we do, of course. And they have to reach maximum medical improvement prior to the completion of a 12-month of modified duty. So that's pretty tough, right, to meet. And then all efforts to accommodate the medical restrictions of the employee have been made and documented. And the employing agency has made reasonable efforts to find other suitable vacant positions within the agency. So there's a job search that happens for that. So you have to meet all those pieces for the workers' comp injury. Non-workers' comp injury, someone who just got injured while walking down the street on a Saturday or something like that. You still have to make efforts to reasonably accommodate the medical restrictions of that employee. That would be an ADA thing too, right? And you also must do a job search for that person too. So you still have some restrictions there, but I think it's a pretty good vehicle when you have someone who has a medical condition. You should take a look at that rather than just, pulling the disciplinary process trigger. All right. So moving on to settlement agreements. So all settlement agreements under the rules need to have director signature. So we need to add director signature to the line there. So we make sure to get that in there. A lot of the attorneys that are handling this should know that they need to have director signature. If there's a payment involved, we typically add DFA's signature as well, DFA secretary signature. Going back to the effective date on settlement agreements and in your letters, please be careful on what effective date you use. So a lot of these we've been seeing, for example, it says, you're dismissed from your position effective June 6th. You'll be paid through close of business June 6th. And then in share, it shows June 7th, right? So that's confusing to the ALJs. Another example, I guess, would be like, hey, your position's dismissed effective December 3rd at 5 p.m. And then the effective date is entered as December 4th. Again, it just doesn't make much sense. So, and one thing we didn't talk about on the admin leave that I meant to sort of come back to was, of course, admin leave, pending disciplinary action. So that is certainly another category. And we have sample admin leave letters that we've developed at SPO. Is probably at your agency, you've got those as well. But those are important to go out and notify the employee that, hey, you're on admin leave, pending investigation, disciplinary action, and it gives the sort of restrictions. You could be called in, and et cetera. But those are important to get out to the employees. All right, so yeah, director approvals. These are some of the areas that require director approval, and you see the percentages up there again. I think that's about it on that. So where to find the rules? So if any of you want to know, I mean, you can easily go to our website, spo.state.nm.us, which our website's undergoing some development a little bit to try to simplify things. But this is where you go to the resources and then go to the State Personnel Board and then to the board rules. And you can find them there. I think we also have a PDF version on our website as well. Both are searchable, and you'll find that searching through those rules are very helpful with the keyword search like director or whatever else your issue is, and get to that fairly quickly. Okay, cool. So, so can we name 3 areas covered by the State Personnel Board rules? Pay, yes. Leave, and what else? Recruitment. So there's 3. Okay, that was easy. All right, so name, my God, I took that slide down. 3 actions that the director approves, has to approve. In-pay, what was that? In-pay band, okay. Settlement agreements. And what else? Reclasses, and then TRETs. Yes, okay. So there's actually quite a long list, as we go back to that. And I'm not sure.
So busy, I'm very busy.
Yeah, that's why you're a busy person. It's always signing. But we hope to also, I think, try to make things more efficient for you guys too. So that's something we'll probably talk about over time as well. But yeah, I don't think this is all inclusive, but it's certainly a good representation of that. All right. So that's all I've got. So any questions? Oh, that's good.